His Excellency the President's utterances about anticipatory bail. Anticipatory bail is provided for in our legislation. However, anticipatory bail is just anticipatory bail. It is a pre-arrest bail. And if it is a pre-arrest bail, it then means that once and when you are arrested, you cannot be kept in custody before arrest. Or you cannot be detained before you are told why you are arrested. Why am I talking about an arrest? Because an arrest is for a purpose of being charged. So anticipatory bail is by an accused person who thinks that they are going to be arrested for an offense that is not bailable. They are therefore going to court to tell the court, in case I'm arrested, let me not be kept in custody. Let me be outside as I answer to the charges. The minute you are produced in court and you answer the charges, the bail application will have to be argued anew with regard to the offense with which you have been charged. I, like the president, I would be agitated because we have people who are being charged with murder, sometimes very serious offense which ought not to be bailable, but they go and get anticipatory bail of 10,000. And they tell you cannot arrest them. It is true. I'm not saying you. I am not saying you. There are people who have anticipatory bail. There are people who have been in the criminal sector. I agree to be faulted. I am not saying the president is right. I am just simply saying the law is there, but it depends. Please just listen to me. Just wait. I have said it is a right. And I know that anticipatory bail, it is a right. I have said advocates have the right to go for anticipatory bail. What I am saying, it is the implementation of the anticipatory bail. We have cases where people with anticipatory bail insist that they cannot be arrested, which is not the... Look at the history of the anticipatory bail in India. And I'm kindly asking you, just listen to me. Let us research together. That is the reason why there is no inter partes hearing in anticipatory bail. Because once you have been brought before the judiciary, you are judicially recognized as arrested. Your bail is now being argued anew as an accused person. What it means is that you cannot be kept in custody. Isn't it? So I am right. You are also right. I am right. You are also right. Yeah? So it is a right, you go to court, but it is not a bar to your arrest. It is a ticket that in case you are arrested, you are not supposed to be kept in pre-arrest custody. Therefore, you have a right to be produced before a judicial officer to argue your bail application. Is that correct? Thank you so much, and may God bless you. But before I go, let me say something. And I think I need to say this. Before I go, let me say something. I think let us always pray for our leaders. Me included. Let us pray for our leaders that we may foster peace, that we may seek justice. Let us also encourage them to create dialogue amongst people and communities. And finally, and I will never stop saying this, actually, and finally, I'm the evidence of the grace of God. And I believe that everything that happens in our lives happens for a reason and at God's own time. And for that reason, I also believe that once you are born, every step that you make, it is a step to your death. Whether you are in an aeroplane, whether you wear a Louis Vuitton, whether you wear Christian Dior, every step that you make, it's a step to your death. And therefore, every step that you make, you must make sure that we make use of the present. And for that reason, may we always pray that our action bring and be in the glory of God, and for peace and love of our families and community. Thank you and God bless. I am deeply concerned about the quality of that ADR. I am deeply concerned about accountability and transparency in that ADR, and I think all of us should be. I know ADR is good, but look at it against a person. There's no equality of arms. You've held this person's money for 5 years. You tell them, do away with the interest. Instead of 10, let me give you 1, and we call it ADR. My friends, is that really fair? So let us work on the quality, transparency, and accountability in ADR as we embrace it. I also wanted to talk about legal education. We put a committee that has looked at the previous reports, and we have an implementation committee now. We want to deal with the transitional issues so that people can be, our training mechanism, inclusion into the law, into the Kenya School of Law can be predictable so that people can know where they are going. Then I was asked this morning about technology and data protection. And my answer was this. The Attorney General is the Registrar of Marriages, Registrar of Societies, Registrar of ABCD. I am keeping them in fiscal records. If I automate that, what is the problem? Because they're supposed to be public documents. So the only thing we are going to do is that in areas, for example, probate and administration, we will not publicize the beneficial owners. We will not publicize the value of the estate. But I think it is our responsibility to let you know that we are holding the estate of so-and-so and it is active or inactive. So wherever I'm called upon to keep records as the registrar, that record is going to be available. This location itself symbolic of our shared commitment to bringing justice and legal services closer to the people we serve. Just as the Indian Ocean connects distant shores, we too must bridge the gaps that separate our citizens from the justice that they deserve. The Law Society of Kenya Annual Conference is always a special moment in the legal calendar, a time when we step away from our daily briefs to reflect together on the larger calling that brought us into this profession. The theme guiding this conference, protecting constitutionalism and the rule of law, ensuring accountability, is foundational. It reminds us that while the Constitution is a supreme law, it does not defend itself. Its protection depends on the collective resolve of men and women of goodwill from both the public and private sector, those willing to speak with courage, act with integrity, and stand unwaveringly for what is right. And we have been told our president is that. The Office of the Attorney General and the Law Society of Kenya may have different mandates on paper, but in practice, we are bound by the same higher duty to serve the people of Kenya by safeguarding justice. This partnership between the Office of the Attorney General and the Law Society of Kenya is not the kind born out of convenience or political expediency, but the deep principled collaboration that emerges when institutions recognize their shared destiny. Whether we serve in the corridors of government or in the chambers of private practice, whether we advocate in the highest courts or counsel clients in the humblest of offices, we are united by a common calling to uphold the rule of law and to ensure that justice is not just an ideal, but a living reality for every Kenyan. That duty to serve all and sundry calls on us to make justice not a privilege for the law, but a right enjoyed by all. It is this conviction that has driven the Attorney General's office work to take our services closer to the people through establishing offices across the country so that no Kenyan has to travel hundreds of kilometers to seek legal support. As the Office of the Attorney General, we are now present in 33 counties, and by the end of this year, we aim to be in all the 47 counties. Not this year, this financial year. As the Law Society of Kenya and the Office of the Attorney General, we share more than just a legal training. We share the same constitutional oath to defend the Constitution of Kenya, the same commitment to the rule of law that forms the bedrock of our democracy, the same understanding that access to justice is not a privilege for the few, but a fundamental right for all, and the same recognition that the legal profession in all its forms bears a special responsibility to be the guardian of these principles. The strategic transformation agenda that the OAG, Office of the Attorney General, OAG, has embarked. As we gather here in Diani, let the rhythm of these coastal waters remind us that just as the ocean's tides are constant and reliable, so too must be our commitment to justice. Let the vastness of the horizon before us inspire us to think beyond our individual practices and institutions, to embrace the larger calling that brought us all to the law. The future of justice in Kenya will be written not by a single institution, but by all of us working together. Let us write that future with wisdom, with courage, and with an unwavering commitment to the principles that unite us. May this conference be more than an exchange of ideas. Let it be a renewal of our shared commitment to guard the Constitution, to uphold the rule of law, and to ensure that justice is not a distant hope, but a present reality. Sorry, it was very long. One of the things that we have found is that we have got so many public interest cases being taken to courts. And I agree that it is our right to hold the government to account. And it is an attribute of the rule of law that persons must have an avenue in which they can fault the act of the executive. However, some of those cases are vexatious litigation. Because you find somebody files against the government, draws almost 10 people as respondents, then within 2 weeks they are withdrawing. They don't want the cases to be decided to the end. Within 1 month, they are withdrawing and they don't tell you why. In some instances, they take the government to court, they take 10 people, then they come and tell me we want to negotiate before the cases are heard. So I just want to tell you, rightly or wrongly, the Attorney General can declare somebody a vexatious litigant. I'm not saying that I'll do it, but there are those cases where, actually, if you look at it, there is more to it than just public interest. And I also wanted to tell you about letters of administration. We have told you that we are operationalizing legal aid, and we are piloting 3 subjects: probate and administration, land cases, and children in conflict with the law. For example, in probate and administration, we have found that in many cases, people get letters of administration and they use it as an accountable document without going back to court for confirmation of beneficiaries and distribution. And in this way, you find so many people, especially women and children, are defranchised. So I think there's a need for us to look at that area. And finally, as advocates, I wanted to tell you about legal fees. I know the government owes you a lot of legal fees. I know that there's a lot of cases that have gone up to the Supreme Court. These cases are as old as 20 years old. Believe you me, it is very difficult for us to deal with those cases. Even when you're writing to me to tell me that the government owes me this much, do this and do this, all I can do is to tell the ministries that you have this judgment against you, what can you do about it? And every time they're telling me they do not have budgetary allocation. And sometimes when you write to me, you tell me this case was decided in 2012, the principal sum is this, the critical amount is this, the interest is this. It is impossible. And then you find some of those ministries have changed hands. Some have been merged, some have been dissolved. So what am I doing now? I want to take account of all these cases. I put it into a cabinet memo, and then I will try to engage to see how we can deal with them. But please bear with us. If it is more than 2 years old, we took it to the pending bills. But even with the pending bills committee, we want to see how we want to deal with these issues of money.
The rule of law is predicated on a fully independent and autonomous judiciary applying known legal principles to ensure grant of access to justice. One such legal principle, which is historically embedded in Kenyan's jurisprudence, starting from our historical underlying from the UK system, and which is one of the pillars of the right to fair trial and rights of arrested persons, is the internationally recognized and practiced principle of anticipatory bail. Anticipatory bail traces its history not only in Kenya's jurisprudence, but has been conclusively and authoritatively established as a fundamental access to justice principle by the Supreme Court of India. For clarity, The purpose of the principle, how it's applied, and the extent in which it's applied in Kenya is informed by the reasoning of the Indian Apex Court in Salahuddin Shaikh versus the state of Maharashtra. You have it. The facade that is peculiar to Kenya is grossly misleading and regrettable. The high standard required for the grant of anticipatory bail is well documented and provides sufficient safeguard against potential abuse of the discretion given to court in granting it. Friends, anticipatory bail is neither a Kenyan innovation granted on whims, nor does it amount to judicial endorsement of crime. The judiciary is a fact finder guided by the law and evidence, and not to be swayed by political sensationalism. As we proceed with this conversation on constitutionalism, we urge the judiciary, which is ably represented here today, to remain astute to the discharge of its functions regardless of the attacks associated with a highly potent social political scene. While the Constitution requires legislature and the executive to be checks and balances to the judiciary, it does not presuppose that they are competent to play an advisory role on the discharge of judicial authority, nor does it contemplate the threats and coercion. The judiciary must discharge its role without external interference or corruption. Accountability, therefore, remains an important theme in this conference and should run deep in the mainframe of the judiciary to gain public trust in the manner the judiciary carries out its duties.
In line with the principle of innocence of accused persons, our courts have continued to grant bail and bond to accused persons brought before our courts. In instances where parties have been dissatisfied with bail and bond terms imposed by the magistrates, they have swiftly moved to the High Court for review of those terms, and I'm happy to say the High Court has reviewed those terms to ensure fairness and proportionality on both terms. And this is as required in the Constitution, that the only imperative when you are dealing with bail bond application is to ensure the suspect will turn up in court during trial, nothing more. And the bail terms must always be reasonable.